everybody. So I am getting back into the doctrinal episodes of law schoolers, and ultimately this is going to be part 3 of the Commerce Clause. Believe it or not, there's going to be a part 4 as well. But before I get into that, I do want to mention that we have covered a lot of material in the last couple of weeks. By this point, my constitutional law outline is completely updated, but it was 3 weeks behind, including this week, up until today. And so there's a lot of material that I'm going to have to go through. And ultimately, we're talking about Congress's powers. That's all we're talking about, and the limitations on that power as well. So we're going to be focusing in this episode on the Commerce Clause. Future episodes will talk about the federal Congress's taxing and spending power, as well as treaties, and then limitations made by the 10th and 11th Amendments, as well as additional powers granted by the 14th Amendment. Briefly, we'll go over powers granted by the 14th Amendment. But let's go ahead and talk about the Commerce Clause. Up to this point, we have mentioned that there have been 4 stages of the Commerce Clause. First was an expansion of the Commerce Clause. I believe that was stage 1. And that'll be Gibbons v. Ogden. And then we talked about the first limitations, that's stage 2. That was Hammer versus Dagenhart. I would say that the first expansion was stage 1. First limitations was Hammer versus Dagenhart. That was the only case with that. Stage 3 was the second expansion through the New Deal. That was going to be cases about United States versus Darby, Wicked versus Filborn. And then we have our third expansion with the civil rights cases as well, and that's the Heart of Atlanta Motel versus the United States, and Katzenbach versus McClung. And now we're finally on to this 5th stage, which is taking it back in time a little bit, going back to a second limitation, is what I call this 5th stage. And we have 2 cases, main cases, that we're really going to follow up with, and then a couple of smaller cases that I just briefly want to mention. Our first case is United States versus Lopez. The act in question here was the Gun-Free School Zone Act, and it was saying that you can't take, well, it's a federal act saying that you can't take guns onto schools. And so this is getting into the police powers a little bit. But ultimately, the majority says that there's 3 different types of commerce. There's channels of interstate commerce, and there's instrumentalities of interstate commerce, so that's going to be persons or things, even if that is local. And then finally, there's the substantial effect. And most of our cases that we've talked about have focused on this third category of the substantial effect. Our big takeaway from this case is that the activity that is going on needs to be economic. Carrying a gun on the school was not an economic activity, and as a result, Congress was not allowed to regulate that activity in the Gun-Free School Zone Act. As a result, that clause at least is unconstitutional because Congress does not have the commerce power to enforce that provision. We have another case, Morrison, just briefly. It furthered this principle by saying that a statute it furthered the statute saying that this principle saying that a statute in that case did violate the Commerce Clause. Hold up 1 second. I'm going to go back just a little bit. A big concern that people had with Lopez is like, well, the statute just wasn't written right then. It should have just said, okay, Congress has the right to regulate commerce that is associated with schools being on school property. And Morrison went on to go ahead and correct that error, saying, okay, this relates only to the commerce associated. But the court still turned down that law, and that was the interesting thing with Morrison is even though Congress went on to correct the language of the statute, it ended up being turned down because there was no economic factor there again. We do have a case, though, that kind of seems to be leaning back from this restrictive approach back into a slightly more modern, expansive approach, and that's going to be race. It's a pretty controversial case. It's a person who is growing marijuana in their backyard. All local. They were going to be using it only for themselves for medical purposes. But the reason why the courts turned down this statute is because federally marijuana is I think Class A, I think is the proper term for it, but it's a Class A substance. We'll go with that. Highly criminal, and as a result, the Congress upheld the statute because it can have a substantial economic effect on other criminal activity as well. Our second main case is the National Federation of Independent Business versus Cibulis. I think I pronounced that last name right. I'm not 100% sure. But this is the Affordable Care Act, or Obamacare as it is commonly known. There's a lot of background that I need to give about this case before getting into the Commerce Clause part of this case. First, there are two main parts that are at issue in this case. There is an individual mandate, and there is Medicaid expansion provisions in here. In both those cases, those provisions are highly contested. I'll get into more of those later. This part of the case that we're focusing for the Commerce Clause is related to the individual mandate. So that's one part of this case, that background info that needs to be known. The second part of this case of background info that needs to be known is there's one majority opinion and several dissents. And what I mean by several dissents is that the majority opinion was written by Chief Justice Roberts. And you can think of Chief Justice Roberts as trying to stand in the middle. He's trying to bridge the divide. He's trying to find a balance, so to speak, if that's the way you want to look at it, at least. And so he creates several holdings, and just to list off the holdings, the individual mandate is unconstitutional through the Commerce Clause. The individual mandate is constitutional through the taxing and spending power. But the Medicaid expansion is not constitutional through the spending power. And so you have Roberts, who says these holdings, and then you have the other justices who grab onto these holdings. They want to pick and choose which holdings that they have. And so you've got a joint dissent, and then you have, I'm going to call it the Ginsburg dissent. The joint dissent agrees that the individual mandate is unconstitutional underneath the Commerce Clause, but also thinks that it should be unconstitutional underneath the taxing power, and then agrees that the Medicaid expansion is unconstitutional. The biggest reason why it's the joint dissent is because Roberts ends up holding that the Affordable Care Act ultimately can still go through because you can sever those provisions off of the Affordable Care Act and it still works. And so the majority opinion says this is still fine even though these parts aren't fine, and the joint dissent says no, none of it is fine, and as a result it should all be unconstitutional. The Ginsburg dissent says that disagrees with the majority approach that the individual mandate is unconstitutional under the Commerce Clause, but agrees that it is constitutional underneath the taxing power, and then also disagrees with the majority approach that the Medicaid expansion is unconstitutional underneath the spending power. In this episode, we're only focusing on the individual mandate for the Commerce Clause. In the next episode, we're going to talk about the taxing and spending power, which is going to get into those other parts of the case as well. Okay, with that said, all that background info, what's our takeaways? The first takeaway is that the individual mandate does exceed congressional authority underneath the Commerce Clause. The main argument from the majority opinion is that the mandate causes people to become engaged in the marketplace when they were not engaged in the marketplace and to begin with. According to the Constitution, the Commerce Clause does not have the authority to compel people to engage in activity. Instead, it can only regulate. And Roberts says that it's not the role of the court to create like a metaphysical theory, which is what the dissent does, and I'll get into that in just a minute. But the main takeaway from that point, inactivity is not commerce. That is the biggest takeaway from this case. If those are the 4 words that you want to remember, inactivity is not commerce. So in other words, not being active in the market does not give Congress the authority to allow the market to make someone active in the market. Okay. The Ginsburg dissent says that people are active in the market, and this is because everybody will eventually need health insurance, or health care. About 60% of the population need health care within a year, and 90% need it within 5 years. This is the metaphysical theory that Roberts does not like, because it's saying people aren't active now, but they will be, and it's pretty much a guarantee that people will be within at least 5 years. And so Roberts doesn't like to draw that line. Ginsburg says pretty much because it's a guarantee, they are active in the market. And when I say active in the market, that means health, and they're actually shopping for health insurance. I'm sorry, I should have given an overview of what the individual mandate did. What it did, so it required private companies to provide health insurance to employees, and it said that people needed to pay for private health insurance if it was not provided by an employer. If people did not pay for private health insurance, well, then they had to go ahead and pay a tax, so to speak, to cover this, to minimize the cost that insurance companies have to insure everybody. So that was what the individual mandate did, is compel people to pay for health insurance even if they didn't have health insurance. Okay, getting back into Ginsburg's dissent once again. She also says that inactivity in the market does affect the market. So by people sitting around on the couch doing nothing, it causes companies to raise insurance rates, which ultimately means that people have less jobs because you don't have enough money to pay employees. Rates go up, so people not being engaged in the market increases the market costs. And because of this drastic effect, Ginsburg is saying that the individual mandate does fall underneath the Commerce Clause power and gives authority to Congress to say that this mandate is fine. So ultimately, on a policy level, unrelated from the legal analysis, this is really just a debate between socialism and the free rider problem. The majority, you can say, quote unquote, is a little fearful of the socialism aspect of this because they don't want people to pay if they're not getting benefits. And then the free rider problem on the other side says you can't just sit around doing nothing and then expect to walk into an ER and get the care that you need for practically no charge at all because you don't end up having insurance. Okay, so that is our big takeaway from NFIB versus Cibelis and United States versus Lopez, with the further notes of Morrison and Raich. Big takeaways when it comes to substantial effect. Ultimately, activity needs to be economic, and it needs to be activity in the market. Inactivity is not considered commerce. Those are big takeaways from the Commerce Clause from this statement. Thank you, and bye. Thank you for listening to this episode of The Law Schoolers. Before I let you go, there are 4 things I want to say. The first thing is if you enjoyed these episodes and if you enjoyed the website, I would invite you to go and join Law Schoolers Pro. And you can do that by going to lawschoolers.com/join. It's a way for you to support us, but there's also a lot of features there that I think you will enjoy. Second thing is that nearly all of our episodes are unedited. The only ones that aren't are pre-law materials, and the reason for that is so you can actually see the legal material in its raw form as I'm learning it as well. The third thing is that the information contained in these episodes are specifically only for educational purposes. They're not to be used as legal advice, and with that, the fourth thing is if it is used as legal advice, we are not liable. That is, Law Schoolers is not liable for any legal outcomes. Thank you again for enjoying the show. Have a good one.